So for any of you who are having difficulty wrapping your head around what is or isn't an emotional support animal, we're going to talk about that today. So here's a classic story of how the subject even comes up. You've had a tenant for a few months, and as far as you knew, it was them, some kids, and that was it. There wasn't any mention about any pet, there wasn't any mention about any animal, but a few months in, you're there working on a toilet because you were called in for a repair, and you notice that all of a sudden they have a creature living among them. And you ask, because this is news to you, when they got their pet. They tell you, oh, he's brand new, we've only had him a few days. And you don't say much, but you pack up your things, you finish up with your repair, and then you hit them with a notice of default for violating the pet provision in your lease, because your lease is clear, no pets allowed. Your application was clear, no pets allowed. You've mentioned it more than once that a pet is not allowed, and you tell your tenants they've got 7 days to get rid of the pet, but they refuse. In fact, you send notice after notice, and they continue to refuse to get rid of their new dog. So push has come to shove, and you've issued a notice to vacate, and now you find yourself in front of a judge, and for the very first time, your tenant uses as a defense, Your Honor, this is my emotional support animal. And the judge agrees, and your eviction case, tossed out. What do? Well, first, you got to understand what an emotional support animal is. It's essentially a medical device. An emotional support animal serves some emotional function for someone with a medical need. And so, no, it's not some made-up thing. The Fair Housing Act requires you to allow them to stay. In fact, you can't use this in most situations as a basis for removing a tenant, even if your pet policy is clear, because at that moment, that animal is not a pet. This means you can't charge a pet fee, pet deposit, or pet rent. Whatever it is your lease refers to it as wouldn't apply to an animal that's technically an emotional support animal. Have you ever had a tenant sneak in an emotional support animal that wasn't legitimate? How did you handle that situation? So you might have some familiarity with certain service animals, like guide dogs who service individuals who have limitations with their eyesight or some kind of vision impairment. But these emotional support animals are a little bit different. In fact, for most situations, you can't tell that a person requires an emotional support animal just by looking at them. And so it makes it difficult for you to be able to determine whether or not it seems appropriate. Someone with 100% blindness and a seeing eye dog is very easy to point out, but emotional issues aren't out there in the open, and you have almost no way of knowing for sure that this individual has this issue and requires this animal. So what do you do to make sure that you are not being taken advantage of? Well, the law does allow you to investigate the matter so that you make an informed decision when you allow someone to reside on your property. Even though pets are disallowed, they can reside there because this is not a pet. So what sorts of questions can you ask? A lot of times when someone comes forward and says, no, this is an emotional support animal, and a landlord just asks, well, I didn't know you needed a support animal. How do I know this is legitimate? And the tenant says, oh my gosh, you can't invade my medical privacy, and you can't ask questions about my emotional support animal. Not true. You can ask if the tenant has anything in writing from a medical professional that establishes that they are under the care of a medical professional and require an emotional support animal. In fact, that same document that establishes the need for the emotional support animal might also establish that the animal in question satisfies that need and serves that purpose. But you can ask your tenant to supply you with something in writing from a medical professional that establishes these things. And if the tenant is unable to supply you with evidence that they have the medical need for an emotional support animal and that the animal in question serves that need, you can rightfully deny them access to the unit with that animal. So this happens whether or not it happens at the beginning of the lease, at the time of application, or in the middle of a lease, because it is possible for an individual to develop a need that didn't exist at the time of application, but does presently exist now in the middle of a tenancy. But if you don't ask and you simply take your tenant's word for it, you may be allowing your tenant to take advantage of you not asking that very important question. Because sometimes tenants don't tell the truth. And because of that, you need to stay on top of the game and make sure that if your tenant has an animal and they're claiming it's an emotional support animal, that you've asked for this small amount of verifying evidence. Again, it's usually some letter from a doctor. The next thing that you should do is when you've received that letter from that individual's healthcare provider, that you call and confirm the legitimacy of that letter. You can call and confirm that the letter that was sent to you comes from an actual medical service provider. If nobody answers the phone or the phone number is disconnected, you probably have some fraudulent document in front of you. If you attempt and make a good faith effort to confirm the legitimacy of a notice that appears to establish that someone has an emotional need for an emotional support animal, but you can never confirm this from the actual healthcare provider, you may have very solid grounds for denying the request of your tenant to allow them to be there without paying a pet fee, a pet deposit, or pet rent. Now, while people have all sorts of animals that satisfy this definition, not every animal will count. If the animal in question is otherwise not allowed in a residential setting by the laws of your jurisdiction, that alone is a sufficient cause for you to deny the request. Understand that the law requires you to accommodate a reasonable request. However, if it turns out, for example, that you have a medical condition with a severe pet allergy, and such an allergy is going to prevent you from even entering the home to make inspections or conduct repairs, which are things that you would normally do on your own, but can't because of the presence of that animal in your home, it is possible that you can deny the request for an emotional support animal on this basis. Make sure that you can validly demonstrate that your medical needs would be put at risk by allowing such an animal in your situation. So imagine that you have asked your tenant to supply some evidence verifying the need of an emotional support animal, and they simply have not provided it. If that's the case, and you have denied them access for that particular animal, but they continue to keep the animal on the premises, you have every right to cite them for a notice of violation and to charge them any fees that your lease allows. If this turns out to be the basis of an eviction, then you can validly present your case, and if the tenant still cannot produce the evidence required to establish this emotional support animal or their medical need for it, you will prevail. However, even if they produce it as late as the day of trial, you may find yourself in a position to have to allow the tenant to keep that animal in place. But what if, for example, they get permission for one animal and have other animals? Understand that the law does not give the tenant carte blanche when it comes to animals other than their one emotional support animal, if that's all that is required for their medical needs. So for example, if one child has a medical requirement for an emotional support animal, that does not mean that the rest of the family can also each have an emotional support animal. The fact that the tenant can prove that one of these animals is allowed as an emotional support animal does not automatically mean that all other animals are also allowed under that same definition. For each animal, they would have to meet that same threshold requirement. And if they simply do not, you can issue notices regarding those animals, again, if there is no substantive evidence that they serve a medical need themselves. But Ernie, what about all of the damage that that animal is going to cause? Well, in many instances, animals cause no damage. Depending on the size and depending on the access they have to the premises, they may cause none. For those of you who don't collect a pet deposit because you have an emotional support animal and you are not allowed to collect a pet deposit, where the animal does no damage, you have no harm. But in the event that you have an instance where someone has a legitimate emotional support animal that is causing actual damage to your property, the fact that this is an emotional support animal does not preclude you from issuing notices of default and issuing bills for the cost of repair when that animal has caused harm to the property. Remember, the limitation for this individual is that they can have the animal there, not that the animal can destroy your property at will. If it turns out that an emotional support animal is causing physical damage to your property, you have the impetus to act even quicker than you might otherwise act because there is no deposit in place at all for this animal. You know that initial harm will lead to more harm. And so by acting quickly and issuing a notice of default and repairing the damage and then issuing bills to that renter, you are the most likely to collect and to leave your property unharmed than if you just wait until the end of the tenancy. Remember, if you're waiting till the end, you may not have access to a full set of remedies if the security deposit itself doesn't cover all the damage that you were unable to collect a security deposit for that pet for. By acting quickly to prevent your tenant from continuously allowing their emotional support animal to cause damage to your property, you might be able to evict this tenant and spare yourself thousands in losses due to the damage from that animal. I've had a number of clients who tell me some pretty awful stories about damages that pets have caused to their property. What's been the worst thing that's happened to you on one of your properties? Share your comments below. One final piece of advice would be to add at least one more inspection date to your normal list of inspections. If you've watched my channel enough, you know that I recommend at least 2 inspections during any 12-month period, once after the 3rd month and once after the 9th month. But in this case, you might have to do quarterly inspections, once after the 3rd, once after the 6th, and once after the 9th month, just to make sure that an emotional support animal isn't causing harm, or that if an emotional support animal has caused harm, they're not causing additional harm later. You need to make every effort to make sure your property is protected because it is your most important asset. And the fact that a tenant might have a right to have an animal there without paying pet fees, pet deposit, or pet rent doesn't mean they can destroy your property. By adding an additional visit to your tenancy, you can ensure that your property will be safe, and if harmed, that you're issuing notices to your tenant and having them pay for those repair costs. Landlording can be difficult, and when the laws change to something that's brand new, it can be confusing. It's important for you to be able to know that there are experts out there who can help define some of these nuances in the law and offer excellent advice to you when it comes to dealing with the changes in the law and their effect on your rental business. If you enjoyed this video, I hope you give us a like. There's a ton of other content on this channel that's perfect for you. In fact, YouTube seems to think this video right here is the next best thing for you to watch. I hope you check that out. And until next time, landlords, happy leasing.